We were sent here by court order. We were also sent, the governor vetoed the bill, and we were sent here to pass 2 congressional maps. And we didn't do it. We worked diligently as a caucus to ensure that those things happen, and we came up with nothing. I just want to thank our caucus. We stuck together, and I thought it was very important that we work hard for the people that we serve. And I just want to thank everyone for coming, and we want to continue to fight, and this fight is not over. As you know, it's going to go to higher court, and hopefully that these maps will be drawn where we do have additional congressional maps. And again, thank you on behalf of the Black Caucus.
Well, let me say that when we started this process, we started it with the idea that we would follow the court's order. But the first day when the chairman of the Senate and Governmental Affairs Committee introduced the map with one majority-minority district, in my view and the views of this legislative Black Caucus, that was not good faith. When the Speaker of the House introduced the bill with a single minority district, that was not good faith. So we could do it in 6 days, could have done it in 6 days, but this legislature just didn't have the will to do it. And as a result of that, we're here today with nothing done. Louisiana has sent, since its inception, 172 members to the United States Congress. Since its inception, only 5 of those have been black. Since Reconstruction, only 4, all 4 living. All the court has mandated to us was for us to create a second majority black district. We have 6 congressional districts in this state, 2 out of 6, with a population of over a third being black. It's not unreasonable. The population is compact enough to do it. Every person who has opposed one of these maps, not one of them had an amendment to make or produce a second congressional black district. So there was no will to do it. And so now it's in the court's hand. And so we've done all we can do here. And so now we'll move forward. Mr. Duplessis, if you want to add to that, and we'll take any questions from the chair.
I'll just briefly add from the House side how disappointing this process has been, following up on Senator Fields, who I thank for his incredible leadership throughout this process. It was pretty clear from the outset that there was no real intent or desire to respect this court, to respect the legal process, and to respect the redistricting process, quite frankly. To add insult to injury, many members of the Black Caucus, of which I'm a proud member to serve alongside with, had our personal privilege buttons pushed because we saw where this was going, and many of us were denied the opportunity to share our thoughts, to speak on behalf of the people who sent us here. Furthermore, we understand that the video live feed was cut, which is the ultimate insult because you are cutting off the public's ability to hear what was being said, probably because you don't like what's being said. I think it puts an incredible stain on an already tarnished process that we have done what we believe is the right thing, which was to draw districts that are compliant with the law, to draw districts that are compliant with fairness, and respect the court's order. This legislature is currently in direct disobedience of the court's order, and now, as Senator Fields has pointed out, we have to await what will happen, most likely at the appellate level. But we believe we will end up victorious because we know we're on the side of justice. So with that, I think we'll take any questions. Yes, Jared Evans.
As I've sat through hours of committee hearings and floor debates over the past few days, past 4 days, the only 2 words that I can come up to think of to describe what we've seen is race war. We heard from the Black Caucus, we heard from black community leaders over and over and over again, asking for a fair piece of the pie, asking for an opportunity to elect our candidate of choice in 2 districts. And what you heard from the majority was no. Be grateful for what Master has already given you. You should be grateful that you have a chance to elect your candidate in one district. You should be grateful for that. The Supreme Court in Thornburg versus Jingles laid out the test that courts look at in determining whether a second opportunity district for minorities should be drawn. And the first factor is to determine whether the black population is geographically compact and sufficiently large to elect a candidate in a single-member district. We have proven every single Jingles factor up and down, over and over, backwards and forwards. We proved it in February, we proved it in the veto override session, and we proved it again in this veto override session. It's as simple as that. There is no legal reason, and their lawyers have tried, why Louisiana should not have 2 majority black congressional districts. So we have proven that the law is on our side. We have proven that the facts are on our side. And thanks to the Louisiana Legislative Black Caucus, the record is on our side. At every stage of this process, in both chambers, the Black Caucus offered the majority an opportunity to pass a map that would have complied with the judge's order, that would have complied with what the governor called this session for. We are 3-0 in court because of the leadership of the people standing alongside me. So thank you, members, for every motion. Thank you for every vote. Thank you for every bill that was authored up. Finally, I also want to thank our plaintiffs in this case. Ashley Shelton is the president and director of the Power Coalition for Equity and Justice. Devontae Lewis is here as well. They are both named plaintiffs in our case. Coming into this, we were already optimistic about our chances in court. But thanks to the record that was built by the Black Caucus over the past few days, we are confident that once this is settled, justice, fairness, and equity will prevail, and black voters in this state will have an opportunity to elect a candidate of their choice in 2 congressional districts. Thank you.
So the judge has already asked for remedial maps to be due on the 22nd. Are you planning on presenting the maps that Senator Fields and you DePlessis have presented here during the session?
Yes, the SB1, HB1 will be the map that this caucus presents to the court.
And just kind of any response to the map that was sitting in the Senate that was kind of the last hope? What's kind of your response to how it was drawn and how that went down this morning? Well,
it is our position that that map was in court we call it a dilatory tactic. It was a delay, quite frankly. I don't think there was a sincere effort by the Senate or by the House, for that matter, to pass a map, and that's what it was. It was a delay tactic, and they ran out of time. Every person who offered an opinion or an amendment to any of the sincere bills never intended to vote for any of the maps that included 2 majority-minority districts.
Is there anything that's transpired over the last few days that you feel will help your case in court even more so than what you had before this special session started?
I don't think anything that have happened will hurt our case, for sure. I think we have continued to build a solid record, and I think the court certainly know that this legislature will not pass a plan that will include 2 majority-minority districts. Any other questions?
Yes. Judge Dick on Thursday raised the specter of contempt of court, specifically talking about the Speaker. It seems that in the Senate there was at least some pains taken to go through the motions. There was a different approach in the House. Do you think the Speaker has avoided any possible charges, any contempt of court charges, or did he meet that good faith obligation?
I don't want to get in the head of the judge, and I certainly don't want to try to get in the head of the Speaker, but I think if you just look at certain actions that took place, even leading up to this session, I saw the judge's frustration. I sat front row in the court when she asked him point blank, why should you not be held in contempt? Other than him deferring his bill in committee 2 days ago, I don't see what he's done differently to make the judge's position be any different than it was when we were in court. In fact, I think some of the actions that took place today would further go down that path of being in direct violation of what she has ordered this body to do. And it's been blatant, and I think it's been incredibly disrespectful. How we hold ourselves out as lawmakers, we hold our hands up and we take an oath to uphold the Constitution, but then we want to pick and choose and send out tweets to say, vote your conscience, vote your district. We weren't sent here for this session to vote our conscience. We were sent here to come up with a map with 2 black districts, and there was no effort by the Speaker to do that.
All right, one more question.
Any additional questions that you got in hand?
That's all I have. Thank you.
Thank you.
All right, everybody be safe going home.